Greetings from Norman. My name is Joseph Ty, and it's my pleasure to give this explainer on free speech at public universities. So, I'm a constitutional law professor at the University of Oklahoma, and among other things, I teach, write, and litigate about the First Amendment. Of course, in these times, we can all appreciate how fundamental the right of free speech is in every corner of society. Today, we'll be going over the free speech principles governing an especially vital corner, public universities. So, as we have witnessed in recent years, campuses across the country have been roiling in free speech controversies, from encampments protesting the war in Gaza to demonstrations demanding racial justice. So, before we dive into the law of free speech, I'd like to refer to a story from ancient Greece with which you're no doubt familiar: Odysseus and the Sirens. Odysseus had himself tied up and his ears plugged so he could not heed the song of the sirens, their seductive but ultimately destructive call. And in similar fashion, we adopt free speech principles not for easy times, but to bind ourselves in hard times. That way, we stay the course and stay true to our commitment to open inquiry and debate. And plugging our ears is an apt analogy, as we should follow the same free speech principles regardless of the topic or the viewpoint that confronts us and challenges us on campus. So, this talk will cover the basics of free speech, namely, what is speech? Why speech should be free? Whose speech is protected and protected from whom? And how speech is protected by the First Amendment. So, let's begin with the what. In particular, what is speech? Now, some things are obviously speech, such as words, whether written, as on this slide, or spoken, as I'm doing. Of course, actions can sometimes speak louder than words. So, actions or conduct can also be protected speech. For example, saluting and ceremonies, as well as symbols like the flag here on this slide. Sometimes the most powerful messages can come from the simplest of actions, such as standing or sitting or kneeling, whether in prayer or in protest. Of course, silence itself can be expressive. And if you've ever been in a relationship, you know that silence can sometimes speak volumes. And apparently, the silent treatment is not confined to the human species. Next, let's examine why speech should be free. One of the earliest and most often given reasons is that free speech promotes the search for truth. For example, the 17th century poet John Milton, renowned author of Paradise Lost, asserted in a publication against royal censorship, quote, "Let truth and falsehood grapple. Whoever knew truth put to the worse in a free and open encounter." End quote. This is an early formulation of faith in what we now call the marketplace of ideas. Of course, Milton never met ChatGPT, and it remains to be seen whether truth or falsehood will more often prevail in a future where AI is pervasive. As ChatGPT itself has prophesized, there is a simultaneously scary and exciting future where AI generated false stories are the norm. A second justification for free speech is the promotion of self governance, particularly in a democratic society. For example, in a Vietnam War era case that struck down California's ban on the public use of the F bomb, the Supreme Court stated, "The constitutional right of free expression is powerful medicine in a society as diverse and populous as ours." It puts the decision as to what views shall be voiced largely in the hands of each of us, in the hope that the use of such freedom will ultimately produce a more capable citizenry and more perfect polity. That is the theory, at least. Now, a third and more recent justification for free speech is what I call self fulfillment. And by that I mean, first of all, we are the speech that we consume. And secondly, self expression is an integral part of who we are and how we grow as human beings, whether it's reading Shakespeare or Stephen King. I consume both. Or watching or making TikToks. I do neither, but my students do both. Now, let's turn to the who question, namely, whose speech is protected on campus and protected from whom? And in answering this question, as well as the next one, how free speech is protected, my focus is specifically on the protections of the First Amendment. The short answer is that everyone's speech is protected, from students and faculty to staff and administrators. In addition, the public also enjoys the protections of the First Amendment, at least in spaces or at events that are open to the general public. Importantly, as we'll examine, the free speech protections enjoyed by these different categories of individuals very much depend on their particular role at the university and the specific context in which the speech occurs. Now, turning to the second half of the who question, from whom is free speech protected? In answer, consider the text of the First Amendment. It prohibits Congress from abridging the freedom of speech. And in cases by the Supreme Court and lower courts, that protection has been extended against the federal government generally, including the executive branch. But wait, there's more, as the commercials say. After the Civil War, the First Amendment right of free speech was made applicable to state and local governments as part of the liberty protected against state deprivation by the 14th Amendment. So state universities, such as OU, OSU, and UCO, also must honor the First Amendment. But note that private parties, including private universities, are not governed by the terms of the First Amendment or the 14th Amendment. But that said, many private universities have voluntarily adopted free speech principles. They often claim to adhere, at least, to the First Amendment or the so-called Chicago Principles, named after the University of Chicago, which in 2014 articulated a robust set of principles to protect free speech on campus. Finally, how? How does the First Amendment protect free speech on campus? The answer is highly complex and, as noted earlier, highly context dependent. Now, thankfully, it's not as complicated as cat trigonometry, but it is complicated. I spend several weeks, in fact, of class going over how the First Amendment protects speech for different speakers in different situations. But I'll try to give you a sense, at least, in about half an hour or so. Now, let's begin with a general rule that protects most speakers in most contexts on campus, as well as off campus. Like the one ring in The Lord of the Rings, it's the one rule to rule them all, so to speak. Do not censor speech on the basis of viewpoint. Adhere to this one rule, even if the viewpoint is deeply offensive to most people or otherwise objectionable. If the university silences or disciplines speech because it conveys a disfavored view, the censorship triggers the toughest test in constitutional law, called strict scrutiny. And as a result, such viewpoint discrimination will most likely be found unconstitutional. And that's because, for the sake of furthering truth, self-governance, and self-fulfillment, the First Amendment does not allow the government to decide which views are allowed and which are not. So, for most situations on campus, as well as off campus, including online, the First Amendment requires that universities treat all viewpoints on all sides even-handedly. Recall Odysseus plugging his ears with wax. If the situation allows for sirens to sing, you cannot suppress their song because you don't like their point of view. Beyond the general prohibition against viewpoint discrimination, the First Amendment rules governing the freedom of speech depend on the nature of the speaker and the specific context. And because a lot of speech controversies on campus arise from student speech, I'm going to focus mainly on the rules governing student speech. So, in many situations on campus, student speech is governed by a reasonableness test. This test is more relaxed than strict scrutiny and allows more leeway to restrict speech to further the functions of the university. Foremost for me, in the classroom, during classes, universities and their faculty have reasonable leeway to restrict speech to further the educational mission. For example, restrictions on speech like these are perfectly reasonable and hence constitutional. Only attend if enrolled or invited. Only speak if called on. And no disruptions. So note that these examples are called content neutral restrictions. That's because they apply evenly, regardless of the substance of the speech being restricted. So if a student speaks out of turn, it doesn't matter what they say. They can be silenced and penalized. Furthermore, in their classes, faculty can even reasonably limit speech based on content or topic. For example, if it's a calculus class, the professor can silence off-topic speech, such as a student answering a math question with a political statement. On the other hand, restrictions on the basis of viewpoint are likely invalid. Remember the one rule that you have to treat all views equally rather than censoring offensive, unpopular, or otherwise disfavored views. If classroom discussion revolves around a certain topic and students are invited to offer opinions, then views on all sides must be allowed. So these viewpoint-based restrictions are invalid. No feminist views in a history class, for example, or no pro-Israel views in a Middle East politics class. Now, sometimes classrooms are not hosting classes, but serve as forums for official events, such as panel discussions put on by the school or speakers invited by student groups. And the general rule for these kinds of events is the same as for classes: reasonableness. That is to say, restrictions on event speech must be reasonable to further their educational purpose. Therefore, event organizers can reasonably set the format of the events, such as through moderation, can reasonably limit audience participation, such as through Q&A at the end, and can reasonably respond to disruptions, including removing protesters. However, the one rule again applies, and viewpoint restrictions are likely invalid. So if audience views are invited, for instance during Q&A, then all views must be allowed. So the same reasonableness test and the rule against viewpoint discrimination applies to other official events on campus as well, such as graduations. So university can reasonably set the format of the ceremony, can reasonably limit audience participation, such as through applause, can reasonably respond to disruptions, again, by removing protesters. But again, viewpoint restrictions are likely invalid. So for example, at an OSU graduation, there cannot be the rule that no OU t-shirts are allowed. They should be if OSU t-shirts are allowed. Now there's another category of campus space that I'd like to address: those that are not forums for speech at all. And that notably includes administrative offices that students nonetheless have occupied in protest time and again. For example, pictured here is the area outside of the president's office at OU during a sit-in against racism on campus. The test for these administrative offices and other spaces on campus that are not open to the public or students generally is again reasonableness. And the reasonableness test is applied with a dose of deference to the university to limit people and speech in order to carry out university functions. But again, to sound like a broken record, viewpoint restrictions are not allowed and likely invalid. So universities should be wary of tolerating occupations for one cause, but not for another. Such selective treatment may give rise to the appearance, if not the actuality, of favoritism on the basis of viewpoint. The same deferential reasonableness test governs physical property, such as statues and building facades on campus. Universities, therefore, can reasonably limit speech to prevent damage or to disassociate itself from a message it does not want to convey, such as the message here that OU's provost has to go. But again, no viewpoint discrimination, please. So there are other areas and situations on campus and off campus where the First Amendment is more protective of speech, and the corresponding tests are tougher than reasonableness. These tests are known in constitutional law as intermediate scrutiny and strict scrutiny. These tests apply to some critical situations involving student speech on campus. As we've seen dramatically in recent years, rallies, protests, encampments, and other demonstrations can occur and remain on campus lawns, plazas, and other open outdoor areas. Notably, encampments protesting the war in Gaza occupied lawns and plazas at the heart of campuses, from Columbia on the East Coast to UCLA on the West Coast and numerous campuses in between. We need look no further than our own state campuses for student demonstrations on lawns and plazas at the heart of campuses. So, pictured here was a protest against racism on campus at OU in front of Evans Hall, which houses the offices of the president and provost. And here was a rally for racial justice in the summer of George Floyd. Here, a protest against campus COVID policies. And here, a protest against the closing of the American Organ Institute at the music school. Sometimes these protests include marches on streets and sidewalks across campus. So the lawns, plazas, streets, and sidewalks on campus that are generally open to the public, where rallies, protests, and marches usually take place, these are protected First Amendment spaces called traditional public forums. Examples abound on campuses across our state. For example, here's OSU in front of the Low Library, USAO in front of Trout Hall, and UCO in front of the Old North Tower. But don't just take my word for it that these open campus spaces are public forums for free speech. In 2022, our state legislature made it law that outdoor areas of campuses are public forums, at least for the campus community. But this law, HB 3543, was somewhat redundant in my opinion, as the First Amendment already regards these open outdoor spaces as traditional public forums. And notably, the First Amendment protects them as free speech forums for the public generally, not just for the campus community. In these so-called traditional public forums, universities generally cannot censor speech based on the topic or the viewpoint. If so, strict scrutiny applies. And as I've noted, this is the toughest test in constitutional law. It requires the university to further a truly compelling interest with the narrowest possible tailoring or the narrowest possible restriction on speech. Applying this test, the university will most likely lose. And to illustrate, in traditional public forums, universities cannot ban protests on the topic of the war in Gaza, even if it bans all sides. In other words, universities cannot shut down speech on controversial or disfavored topics. Furthermore, universities cannot ban protests only on one side, such as banning only protests against Israel. That viewpoint discrimination would run afoul of the one rule. But to protect the educational mission of universities, they can adopt limited time, place, or manner restrictions. Note my emphasis on limited. There's a common misstatement of First Amendment law that I'd like to correct. Sometimes lawyers and judges, and indeed HB 3543, refer to the test as reasonableness, stating that reasonable time, place, or manner restrictions are allowed in public forums. But the First Amendment demands more than reasonableness. The test is actually intermediate scrutiny, which, as its name suggests, is tougher than reasonableness, but not as tough as strict scrutiny. Under this test, a time, place, or manner restriction on speech in public forums must narrowly tailor to promote a significant government interest, and there must be ample alternatives for speech. To illustrate, a limited time, place, or manner restriction, such as no overnight encampments, is likely valid. It would promote significant university interests in protecting health and safety, given the lack of sanitation, facilities, and security risks, and would also protect lawns and other open spaces from camping equipment, sleeping bags, litter, and other wear and tear. At the same time, the overnight camping restriction is narrow enough to allow non camping protests day and night, so there remains ample alternative channels for student protesters to convey their messages. But a time restriction that flat out bans nighttime protests, say between sunset and sunrise, is most likely invalid. It's not narrowly tailored to promote any significant university interests. It would ban a wide swath of protests of shorter duration, such as vigils and protests that last only a few hours, and that don't present the same significant health, safety, and property concerns as camping that can last for days or weeks. And third, a manner restriction, such as a ban on the use of sound amplification equipment like megaphones or microphones with speakers, is also likely invalid. Universities might cite disruption to classes, studying, or work in nearby buildings, but more narrowly tailored restrictions would further those interests while allowing students to literally be heard. For example, the restriction could be narrower. Don't direct such sound amplification equipment at classrooms, at dorms, or at offices. Now, let's pivot from on campus speech to student speech that occurs on social media or otherwise off campus. Controversies, as we've seen, are often ignited there. In these spaces, which universities do not own or control, speech is often robustly protected. And generally speaking, universities cannot discipline student speech online and social media or off campus merely because it is deeply offensive, discriminatory, or otherwise objectionable to the community. So, to cite an example, note the headline on the slide here states that the OU students involved in this viral blackface video on Snapchat will not return to campus. It does not say they were expelled, which most likely would have violated the First Amendment. Instead, the backstory is that they voluntarily withdrew. Again, this is an application of the one rule against viewpoint discrimination. In most situations on campus, as well as off campus, in furtherance of truth, self governance, and self fulfillment, the First Amendment does not allow universities to decide which views are allowed and which are not. Next, I'd like to explain a critical area of free speech that can cause confusion, consternation, and sometimes pain on campus: hate speech. And to put it in the form of a question, like Jeopardy: when is hate speech protected by the First Amendment, and when is it not? So, the short answer is that hate speech, including vile racist speech, is generally protected by the First Amendment, just as political speech and most other kinds of speech are protected. But there is a notable exception. Hate speech can be censored if it amounts to a kind of unprotected speech, such as fighting words, true threats, or incitement. So, unprotected speech are categories of speech that historically and currently do not receive any First Amendment protection. Therefore, hate speech can be censored and disciplined without First Amendment concern at the intersection of these two circles in the Venn diagram, where hate speech in context amounts to fighting words, a true threat, or an incitement to violence. So it's critical that we understand what constitutes these categories of unprotected speech. Starting with fighting words, they are words which, in the context uttered, tend to incite an immediate breach of the peace. For example, a racial slur shouted in someone's face in a heated argument, such as between the demonstrators pictured here, likely would amount to unprotected fighting words. The person hurling them, in other words, would not have a First Amendment defense to a prosecution for inciting a breach of the peace. Of course, if the other person punches them, they can be prosecuted for assault. On the other hand, playing a popular Jay Z rap song that has a racial slur in it, that's protected speech in most situations. The next category of unprotected speech, true threats, are serious expressions conveying that a speaker means to commit an act of unlawful violence. Because it can sometimes be difficult to tell if a threat is true or not, the Supreme Court has required that the speaker uttering the threat have a conscious disregard of a substantial risk that their communication would be viewed as threatening violence. So, a Snapchat post threatening imminent violence to Asian American students on campus, with nothing in context to indicate that the post is not serious, is most likely a true threat and therefore not protected by the First Amendment. But a speaker at a political rally spewing hateful rhetoric, including racist rhetoric, is protected by the First Amendment as long as the speaker is unaware that the rhetoric poses a substantial risk that others would view their words as threatening violence. Finally, the unprotected category of speech called incitement. Incitements are statements that are 1. Intended by the speaker to produce imminent lawless action, and furthermore, 2. Are likely to produce imminent lawless action under the circumstances. Now, a word of caution about classifying controversial speech as incitement. The Supreme Court is reluctant to find speech to be incitement because, to quote a recent case, incitement is commonly a hair's breadth away from political advocacy and particularly strong protest against the government and prevailing social order. Moreover, the difficulty we confront in our era of extreme politics is distinguishing between intentional calls for violence on the one hand versus heated or hateful rhetoric on the other. For example, when students are targeted by critics who post the students' photos, names, and home addresses on trucks circling around campus as well as online, is that an invitation to target those students for violence or for nonviolent consequences? It can be a close call depending on all the circumstances. Now, let's pivot to another notable and again narrow exception to the general rule that hate speech is protected speech. Specifically, hate speech that contributes to a violation of Title VI or Title IX most likely can and should be suppressed by the university. Like the Venn diagram for unprotected speech, this slide illustrates that hate speech is generally protected unless it rises to a level of verbal harassment that is illegal under the federal laws known as Title VI or Title IX. As you may know, under Title VI and Title IX, universities receiving federal funds cannot discriminate on the basis of race or sex. Hate speech can run afoul of these federal laws because illegal discrimination is defined to include verbal or physical harassment that creates a hostile environment. And verbal harassment is illegal if it has all of these elements. It's unwelcome, it's discriminatory on the basis of race or sex, it's subjectively and objectively offensive, and it's so severe and pervasive that it limits or denies a person's ability to participate in or benefit from the university's education program or activity. So, if these requirements are met, including the last requirement, which sets a high hurdle, then it is commonly assumed that there is no First Amendment problem with disciplining this verbal harassment. So, there is unfortunately no bright line or mathematical certainty as to when speech or conduct amounts to illegal harassment. Instead, As this formula that I've made up illustrates, the analysis is a function of the content of the speech or conduct, the relevant context, and the cumulative nature of words and deeds over time. To illustrate with some horrible examples of hate speech from a book by Dean Erwin Chemerinsky of Berkeley Law School and UC Chancellor Howard Gilman, a noose hung on a tree on an open campus lawn likely does not rise to the level of racial harassment under Title VI, but a noose tacked on a black student's door certainly does. The latter is so severe in its racist, threatening, and targeted message that it limits or denies the ability to participate in educational opportunities on campus. Of course, with respect to the noose on the tree, the university is not helpless to act, even if it does not violate Title VI. Hanging a noose on a tree could violate a rule against defacing university property, as we've discussed, that could apply to symbols of all sorts, regardless of viewpoint. Now, consider the infamous example of the racist chant uttered on the fraternity bus at OU. I agree that the incident alone, as despicable as it was, likely does not amount to illegal harassment under federal law. By contrast, repeatedly yelling racist epithets at minority students on campus certainly would. There's not time for me to illustrate with other examples, but you can find many more on the website for the Office of Civil Rights in the U.S. Department of Education. It offers information on pending and past investigations into universities accused of violating Title VI and Title IX. Okay, so one more thing, like Steve Jobs used to say. No, not a new iPhone, but more relevant and more important for university employees. Recall way back when we considered the question of who the First Amendment protects. And we examined the free speech rights of students around campus and of everyone, including the public, on public forums around campus. Circling back to this question, as a final part of this talk, I'd like to highlight when and how the First Amendment protects university employees, namely faculty, staff, and administrators. So their free speech rights very much depend on the nature of their position and the content and context of their speech. Because this is a complicated area of law, I'm going to lay it out in a table and guide you through it one row at a time. So, first row, when faculty, staff, or an administrator speaks on a public issue, not as a university employee, but as a citizen, then their speech is protected via a balancing test. So, under this balancing test, if the value of their speech outweighs the state interest in the effective functioning of the university, then their speech is protected. On the other hand, if the speech is more disruptive of the functions of the university than the speech is worth, then the university can censor or discipline the speech. Obviously, this kind of balancing is inherently value-based and subjective, but it's what the courts do, so it's what we must too. To illustrate with examples from my own speech, from time to time, I have filed briefs at the U.S. Supreme Court as a constitutional scholar. And these briefs, like this one on the slide, which argued against partisan gerrymandering on First Amendment grounds, expressly state that I'm speaking in my own private capacity. I am not speaking as an OU employee. So the balancing test applies. And on balance, I think I win. I think the value of my briefs outweighs any university interest. On one side of the scales, I offer scholarly expertise to the Supreme Court on a matter of constitutional concern. On the other side, my work on these briefs, done outside of my day job, and the positions I take in them have not disrupted my work for OU or for the broader functioning of the university. Another example pictured here was a March for Racial Justice in Norman during the summer of George Floyd. Lots of members of the OU community participated, including, incidentally, President Joe Harris. We were marching as private citizens on a matter of public concern, and the value of our message certainly outweighed any government interest in the functioning of OU. It occurred on a weekend morning, and no university functions were disrupted to my knowledge. So none of us could be disciplined for that march. Next row of rules. When a university employee speaks as a citizen, but on a matter of private concern, then the location of the speech matters. And by private concern, I mean something that's of personal interest to them, but not of interest to the public generally. So if the speech occurs at the workplace on this matter of private concern, there is no protection for the speech. But if the employee speaks as a citizen outside of the workplace, even merely on a matter of private or personal concern rather than a public interest, then the government still must provide some justification to discipline the speech. The Supreme Court has not said how much, so that remains to be decided. To give an example, suppose I'm fond of posting photos of my cat on Instagram. And this is a hypothetical. I actually don't have an Instagram account, although I do have a cat, this one. So if I post my cat pics at the office, I can be disciplined and fired for it. My speech is not on a matter of public importance, and there is no First Amendment protection for it at the workplace. However, as a citizen, I'm entitled to speak on matters of personal or private interest outside of the workplace, unless there is some sufficient government justification for restricting it. So if I'm posting cat photos from home or from my own phone during a lunch break, then my speech as a private citizen is protected by the First Amendment. Because the content and context of my speech is not disruptive of my work at the university generally, there's really no justification for the university to discipline me for it. Last row. When a university employee speaks as part of their official job duties, there is generally no First Amendment protection. The employee can be disciplined or even fired for doing a bad job. For example, if the football coach has to give a press conference after a game and does a disastrous job, he or she can be fired for it without any First Amendment protection. However, as pictured here, sometimes it is not easy to tell whether speech is part of an employee's job or if the employee is speaking out as a private citizen. Well, enough about Coach Riley. We've moved on, right? Finally, for you eagle eyed observers, the asterisk after no protection in that last row, second to last cell, refers to the caveat that faculty may enjoy some academic freedom protected by the First Amendment and university policy for speech that's part of their job, such as teaching, publishing, or presenting. The Supreme Court has yet to spell out the nature and extent of such protection for faculty academic freedom, so stay tuned. Of course, as I've alluded to, a source of protection for faculty speech is through university policy. For example, OU guarantees academic freedom for research and teaching in its faculty handbook, and those protections are even stronger with tenure. And as a faculty member myself, I feel that this is a positive note on which to end this talk. So, we've journeyed far together, examining the what, why, who, and how of free speech. As we've seen, First Amendment law is detailed and complex. But there is a singular and simple takeaway. Like Odysseus with the sirens, universities need to bind themselves to basic First Amendment principles, such as the one rule against viewpoint discrimination. That way, despite the challenges that universities may face and temptations to censor controversial speech, free speech can thrive on campus as we all strive to further the search for truth and facilitate self fulfillment and self governance. Thank you.